And today I'm going to answer the question, now that you're patent pending, what do you do now? I'm JD Houvener, patent attorney, owner, and founder here at Bold Patents Law Firm. I'm excited to share with you some of my knowledge about today. I've helped thousands of inventors over my 10 years of career and gotten almost 500 patents issued for clients of ours. So let's roll our sleeves up and dig into this question. Once you finally get patent pending, which means submitting a patent application, whether it's a provisional, non-provisional, or a design with the patent office, you're now patent pending. You joined that elite group that has gone through the journey of providing something they believe is innovative, and they're still waiting for the USPTO to let them know whether it's good or reject it. Okay, there's actions you can take and really important steps to be able to move this into the future and have yourself protected and really know how to make the best of this opportunity this time. So the first way to do it is to make sure you know the difference between a provisional and a non-provisional patent application. If you're patent pending, that means you submitted just any application, all right? It doesn't mean you need to tell everyone, oh, it's a provisional patent pending, or it's a non-provisional patent pending, and here's my serial number. It's just any application. So typically, for those that are doing this for the first time, a provisional application is what's filed. And that gives you a placeholder that definitely locks in what's called your priority date, and you must follow it up with a non-provisional application within 1 year. So things you can do to take advantage of that is to understand what is to come, what you need to prepare for in that year to be able to have the best opportunity to have the broadest rights possible and the best patent. I always encourage inventors to try to prototype, if they haven't done already, make the product, take it to market, sell the product, even if it's hand selling, taking it to your friends, family, but you really want to get true customers that you don't know, so they can give it to you straight. They can tell you exactly how well it's working or not working for their particular solution, right? The solution you created, the one that you think this is for the whole world to share. Go get that direct, blunt feedback that you deserve by trying to go sell the product on the market. Once you do that, you'll probably make some changes, okay? Don't get me wrong. You've probably got something innovative and world-breaking, but the truth is, once you sell it, you'll find out what exactly you need to tweak, change, iterate. And hopefully you get to move to version 2 or even 3 in that 1 year of time from when you file the provisional and when the non-provisional must be filed. The beauty of that iterative cycle, right, getting to that design, that final market-ready product, is you can then decide to add detail. You can add more detail to the non-provisional patent application. And that's how you can help you can point your patent attorney to claim, right, to write the claims in the non-provisional to cover the product as it has kind of changed and morphed over that year. The idea, of course, is to match, to make sure what you end up getting a patent on is what is selling. It's a heartbreaking scenario when you go to file the patent application too quickly, you don't make any of those early sales or early prototyping decisions, and you wait for the patent to get issued before selling it. The problem can happen is that, well, now you've got to change the patent, but it's too late. No longer does the patent that was granted match what is selling in the marketplace. And that's the whole point, isn't it? Right now, competitors can come in with a very similar product or the same thing, and your patent isn't worth, right, the time and effort and money you put into it. So understanding the difference between what type of application you file, whether it's a design, a provisional, or a non-provisional, is key to taking advantage of this really a wonderful opportunity of being patent pending. So I'll be answering more questions and specific nuances about what do I do now that I'm patent pending over the next course of series of videos. Hope this lesson was helpful for you. And if you have any questions that remain, please click below. We have our free Inventors kit. This is an awesome way for you to get started. It's a PDF of my book, Bold Ideas, The Inventor's Guide to Patents, as well as your different options for patent searching and patent application drafting. I'm JD Houvener with Bold Patents. Have a great day. Go big, go bold.